Hi, everyone. Can you hear okay? All right, awesome. I'm Amanda Burgess Proctor. Good afternoon. It's a pleasure to be here and to see so many of my colleagues with whom I worked in the Criminal Justice Policy Commission. I am a criminologist and on faculty in the Criminal Justice Program at Oakland University. I've spent the last 20 plus years of my life researching and teaching about crime and working in various facets in the justice system. So what I thought we would do, I've asked each of our panelists today you've heard their sort of, our professional introductions, but I've asked each of them to speak a little bit about themselves, the perspective from which they are approaching this conversation, and also the area that they think is in need of most pressing change or the most urgent need as we have this conversation. But before we do that, I thought I would direct your attention to the recommendations in the report. So we've heard so much about the data. We've had just really fascinating conversations. And I want to take a minute, presentations, I should say. I want to take a minute here to recognize the authors of this report. I know you look at it and you see hundreds of pages and all of these charts and graphs. It's an extraordinary amount of work, and it's just really, really well done. And so I want to acknowledge that and to thank them for their time and effort with that. It's really well done. But on page 171 is where, that's chapter 17, are the recommendations for change. So we've heard about the data, and we've heard about the sort of the practical impact of some of the issues that the report addresses, but the recommendations are what we are here to discuss. What should we do with this information that we've covered today? So on page 171, you will see the recommendations for change. So I'm not going to read the whole entire thing. The first one, establish a commission with the mandate and scope of authority of the former Criminal Justice Policy Commission, which sunset in 2019. Make compliance with the guideline recommendations mandatory, allow departures only for substantial and compelling reasons. And then there's enumerated a series of fundamental structural changes, as well as other recommendations on page 172 for increasing proportionality and for reducing disparity. So it's important that I wanted to make sure everyone at least had the chance to peruse this briefly before we begin talking. So what I'd like to do is to just go down our list, beginning with Judge Shapiro, and just have you talk a little bit about sort of why you're here and what you think we should be focusing on first and foremost.
Yes, I'm supposed to put this on. Sorry. I sit in a somewhat different position. Well, I guess we all do. I was talking earlier with a colleague about it, that, I don't see the downward departures. And so it was kind of stunning to read the report and understand how many downward departures there are. Where I sit, there's only upward departures, often extraordinary upward departures. And so that's my bias in a sense. I have a lot of questions about the sentencing guidelines. I mean, I remember when I was a clerk, and then when I worked at SATO for a while, I never really understood the empirical basis for any of the numbers in the guidelines, and I still don't. And it seems to me that the process has largely been, let's just build it and we'll see what happens, but nobody's ever going to see what happens. And the modifications that are made are not done with a view towards an overall systemic problem, which is, I was sitting down to write my thoughts, and then I turned to page 171 just to refresh my recollection. I realized, all my thoughts are right here. Mm-hmm. So that's kind of where I come from. I think we need a wholesale change of approach. I find certain things in my work to be particularly difficult, which is just some small things. For example, when there's going to be a deviation upwards, or there doesn't seem to be, the guidelines are all presumptively okay, et cetera, et cetera. There seems to never be any discussion about the fact that the guidelines are a range, at least from where I sit, that, it may be 5 years to 8 years, and that means the guidelines are 8 years. As opposed to, you could have gotten 5 years, but you've done X, Y, and Z, and so I'm going to give you the top of the range. That seems to be lost. I think that We tend to get lost in the trees and lose the forest in these long and difficult disputes over how to score an OV13 or OV4, whichever it is. These are important. But the fact is, these are really largely minor issues when you look at the broader problems that have been described in the report. And yet it creates the somewhat of an illusion that we're doing something. You know, we're modifying or we're revising the guidelines to be more accurate, but I don't really think we are. The problem of ranges from where I sit is enormous. I had a case that we worked on this month where the range, from, of course, it's a long habitual, but the range was 61 years from the lowest possible sentence to the. How do you review that? You know, what is an appropriate sentence in a range of 61 years? And I don't know how much time we have, so I guess I will just stop there and pass it on and then wait for my chance to say something else.
Good afternoon, everyone, and thank you for inviting me here. And I can say that I really learned a lot. I had the ability to get this report prior to coming here. And prior to, I guess, receiving this report, I guess I never really thought about where the guidelines came from. As a judge over at the Third Circuit Court, I only oversee a criminal docket. And so we're constantly calculating guidelines. And I appreciate the fact that there are guidelines there. There's something to kind of tell me where I should be sentencing, where the sentence should fall in. But I do agree some of those ranges are particularly enormous. I think that one of the things that I heard today that I used to actually say to a certain extent when I was a prosecutor is justice depended on who your prosecutor was, who your defense attorney is, and who your judge is. And that's unfortunate. And I think the guidelines try to, I guess, really rein that in a little bit. But one thing that was striking to me is that these guidelines, as mentioned before, were put into place at a time when we had these policies of being tough on crime and really increasing incarceration. And it's been 30 years since we've really taken a whole systematic approach at looking at them. So when I look at what my biggest policy recommendation would be the establishment of a commission to oversee the guidelines. I think all the suggestions are suggestions that we should be talking about, that we should be discussing in the broader context of how does this all fit in. And I think it's unfortunate that it's taken this long, hopefully, to start this conversation in a meaningful way where there can be a commission and we can start tackling some of these issues. And so I guess I'll let someone else speak.
Good afternoon, everybody. I grew up with the sentencing guidelines. My first job out of law school was clerking for the Chief Judge of the Eastern District of Michigan. I started in 1987. Shortly thereafter, the federal sentencing guidelines came out in their first form. And for those of you who've been around long enough, you'll remember the initial guidelines were about that thick. You could put them in a 3-ring binder and they were easy to manage. Now, of course, they're more complicated than the user manual for an F-35 fighter jet. I say that because I had so much experience with the federal sentencing guidelines that was really my perspective in the first instance. After I clerked, I was a federal prosecutor in Detroit. After that, I ran the Federal Public Defender's Office in Grand Rapids, and after that, I represented private clients. So I got an opportunity to see quite a bit before I even hit the state bench. What I'll say about the federal sentencing guidelines before I get to the Michigan guidelines is that they proved two things. First of all, that if you really want to enforce relative uniformity and proportionality, you can do it. But second, it requires an enormous investment of assets. The federal sentencing guidelines were amended and amended and amended. Every single time the commission had an aberrant decision, they'd amend the guidelines again. And so from one day to the next, you couldn't even tell what the guidelines prescribed anymore. And the second thing is that the judges on the U.S. Court of Appeals had to be extremely busy and aggressive enforcing the guidelines. And even then, I mean, trial judges are trial judges. They don't like to be told what to do. I had one case where we had appealed, and I'd handled the appeal, and we got Judge Cohn reversed because he'd struck a guideline as unconstitutional. Well, it came back, and he called us in from one of his famous in-chambers meetings, And it was clear that he was extremely unhappy with me for getting him reversed because the case had gotten a lot of publicity. And he sat down and he said, well, what are you going to do to me if I give another 6-month sentence instead of giving the 18 I'm supposed to give? What are you going to do? And I said, we're not going to appeal. Just don't strike the guideline as unconstitutional. He broke into a broad smile and said, see, the guidelines work perfectly as long as no one appeals. And I think there you see a lot of the tension that I think we're going to find in Michigan as well if we start to work with these again, because trial judges are a kind of an independent breed, and we don't have to get anyone to agree before we do anything. And so one of the hats I'm wearing today is as the president of the Michigan Judges Association, and I'll try to be clear when I have that hat on rather than my Chris Yates, former prosecutor, former public defender, former criminal judge. Because I will say, from a personal perspective, the guidelines dramatically need to be changed in a couple of significant ways. First of all, if you want judicial buy-in at the trial court level, I would strongly suggest that one of the things you do is follow the path of my former partner who's now on the House Judiciary Committee, David LeGrand, and build into the guidelines reductions. It is unthinkable to me that you would set up a guideline system like Michigan has and every single offense variable would be an increase and not a single offense variable would be a decrease. That makes absolutely no sense. Why there are not reductions for minor role in the offense or for acceptance of responsibility or for any number of downward adjustments that are available under the federal guidelines has never, ever made any sense to me. And I don't know how they got put together that way, but there's a bill. I don't know whether it's been formally introduced yet, but it's in the works to build in 10, 12, 15 OVs that would result in reductions. The second thing that I would say about the Michigan guidelines is I'm certainly sensitive to the fact that some of the ranges are so broad as to be almost absolute grants of discretionary authority to the sentencing judge. And to the extent that that can be reined in some, that's all to the good as long as it's done within the confines of our 2/3 rule in Michigan. And then the final thought I'd offer is that I hate to ask the Court of Appeals judges to take up this calling, but for those of us in the trial courts, we really don't know half as well as you might think whether our sentences are wildly inconsistent with what's happening in a county across the state or even in a courtroom just down the hall from us. One of the difficulties of being a trial court judge is it's really isolating. Before you get to the trial bench, you understand what's going on in all the courts where you practice. Once you become a trial judge, the only thing you know is what happens within the four walls of your own courtroom. And I can tell you, just on my floor where I have chambers and two other judges have chambers, I have two colleagues, both of whom I like quite a bit because I spend a lot of time with them, and their sentences couldn't be more inconsistent. I mean, and so depending on whether you draw the judge in courtroom 11B or courtroom 11D, the outcome from a sentencing perspective could be dramatically different. Now, I get that different judges have different sentencing philosophies, and you're never going to get all of us to sentence completely consistently with one another. But I do think that if more judges were exposed to the kind of data we're getting today, and particularly in the context of how that meshes with their own sentencing practices, it would do a world of good. Because I think a lot of us just think that the way we sentence is the way we should be sentenced. I was a quintessential guideline sentencer. I never once departed upward. In the cases where I thought the guideline range was too high, I usually tried to work with the prosecutor and the defense attorney to modify the charge in some significant way to get to a fair result. I saw that happen in federal court where a fair number of judges would bring the lawyers and the prosecutor and defense lawyer and say, okay, the sentence is too high. How are we going to make it work? And all of that would happen off the record. And then we'd go in and the objections would be made and everybody knew what the outcome was going to be on the objections and we'd get to a fair sentence in everybody's view. But I do think that education of the trial bench would be really helpful. So I'm sorry I went on a bit long, but I have an awful lot of thoughts about this, and thank you very much for letting me share them.
We have oodles of time, so everyone should. I'll nudge you if you need. Okay.
Thank you. So I've been a lawyer since 1981, and I was a judicial law clerk of a circuit court in the 82 and 83 before I went to the prosecutor's office. So sentencing guidelines were discretionary and just coming into effect, the judicial guidelines. And during the entire time I was an assistant prosecutor, they were also discretionary. The legislative guidelines that we're talking about that are now old did not exist when I was an assistant prosecutor. So, the role of guidelines, I think when I came back as the elected prosecutor after 22 years of being gone from prosecution, I could really see some fairly dramatic differences. And there were a number of practice changes that really resulted. And one is that we do an extraordinary amount of sentence bargaining in Ingham County, a little less now than we did when I started, but because to try to deal with that incredible uncertainty with these ranges that vary so much. So in my 11 years as an assistant prosecutor, I started seeing certain patterns, and now as the elected, I'm seeing how they fit in with charging decisions, sentencing decisions, and the sentence guidelines. And some of the things that were raised by Barb and other people here today are ones that, as the prosecutor who's trying to achieve justice, I'm very concerned about how we look at criminal history, how we look at the double counting of some kinds of either elements of the crime or things that count as prior record variables, how we score multiple prior convictions, which were designed to see if you had a chance for rehabilitation between one conviction and sentence and the next, and things of that nature. And of course, race equity was something that I was very concerned about, both in misdemeanors and certainly with felonies. I knew right away when I came into the office that I wanted to start working with data, which is absolutely not a skill I have, but I knew how important it was. So by looking just at some of the things that were pending right then and some of the national patterns, first of all, right away, I had the opportunity to look at juvenile life without parole and did have those resentenced immediately because philosophically, I'm not a supporter of life without parole. I believe everyone should be reviewed. I believe in second chance reviews, and certainly for juveniles. So that was one of my very first decisions, was that we would resentence on the juvenile life without parole, and that all waivers would have to come through me for permission. And again, these were to try to avoid the huge discrepancies between somebody, like say if you have 3 15-year-olds involved in an offense, and you might have one who ends up in the juvenile system for 4 years, one who goes to prison, life without the possibility of parole, and someone else who did 8 years in an adult prison or something. So looked at that. The other thing I did almost immediately in 2017 was modify our habitual offender practice and policy. I've amended it once since, and will need to do so again. But basically, it's to try to look at those things such as the number of prior convictions arising out of the same transaction, which technically can all be counted towards augmenting the sentence exposure, but it makes no real sense. So our policy is you're not supposed to do that. So if you have 3 felonies arising out of the same transaction, that you're only going to have, if you're habitualized at all, it'll be just one of those habituals. So those are a number of things. Some of you may have heard that more recently I've had policies regarding resisting and obstructing police and felony firearm, which came out of the Safe and Just Michigan report, and not having a policy with a serious look at not charging with non-public safety traffic stops where there's a search and amazingly enough, usually carry a weapon or drugs or other contraband are recovered. So my approach to the sentencing guidelines really came from knowing from being an active prosecution the racial and economic disproportionality I was seeing. And so, and I'm going to stop in mere moments, but I finally was able to get the agreement with the Very Institute of Justice, and we've been working with them for about 2 years now. We're finishing up. And to look at our data as best as we're able to get it, which is always a problem with prosecution data, and then to make recommendations. And right now we're in that stage where we're looking at, for example, how do we look at criminal history in making charging and plea bargain decisions when we know that if you are a person of color, your chances of having a criminal record are going to be much higher than if you are a white person? So what is the proper role of looking at criminal history, for example, when I'm deciding whether to charge between a misdemeanor or a felony, or what sentence, kind of plea bargain or sentence agreement we might be reaching? So there are a lot of things that I'm hoping that we will be able to do that will kind of pull these threads together. But when I came to it, it was the primary understanding that for people in poverty and for persons of color, that the system doesn't necessarily work terribly well for anyone, but it really doesn't work for those individuals. So that's been kind of my primary focus on what I'm doing as the elected prosecutor.
Are you looking at me? All right, I'm guessing I'm supposed to speak. So, hello, everyone. I can see the panel. I can't see the audience. I thank Safe and Just Michigan for allowing me to appear virtually today. That's very generous of them. And I like the recommendations that were made by the other panelists, especially the one by Judge Yates about the reductions built into the guidelines. When I started practicing at Sado, it was right before the second edition of the judicial guidelines came into effect. And to tell you the truth, I'd forgotten that the first edition had some reductions built in. And when I was first reading this new guidelines booklet that was put out by Safe and Just Michigan, I thought, that doesn't sound accurate to me. So I went into my basement and I found that original guidelines manual, and lo and behold, there were reductions. They didn't last into the second edition, but there were a few reductions. So it would be great to see reductions coming back into the guidelines. But what I also thought I would talk about is on page 172 of the booklet, there's a recommendation that armed robbery be moved from a Class A to a Class B, and that unarmed carjacking be moved from a class, I think it's an A, to a Class C. I think moving it to C would make it consistent with unarmed robbery. And, I like those recommendations, but I would go much further. So toward the end of my time with Sado, I had focused quite a bit on felony sentencing, and I was teaching it. And so I wrote an article where I looked very broadly at increasing penalties in Michigan. And one of the things that I saw that was that with the legislative sentencing guidelines, that after they were enacted in 1999, that the legislature went in on what appeared to be a very piecemeal basis, and they would change maximum penalties and move crimes to higher crime classes. You almost never see reductions, except for the recent jail task force legislation, but you could trace a lot of increases over the years. And without a sentencing commission, it really seems like we've lost that hierarchy of crimes in terms of ranking crimes in terms of seriousness. And I'm going to give you an example that I had put in the article I'd written. So I think today we talked mostly about Class A offenses, the life maximum penalties, assault with intent to murder, CSC first degree, and armed robbery. And I think most of you are familiar with some of the common Class C offenses, which correlates roughly with a 15-year maximum penalty. And those are unarmed robbery, manslaughter, drunk driving causing death. But it's the Class B that I find interesting because that corresponds roughly with 20-year maximum penalties. And you have the strangest crimes in the Class B, and crimes that I think don't necessarily make sense, in part because the guidelines legislation, the original, legislative guidelines, there was a guiding principle that crimes of violence against a person were supposed to be treated more severely than other crimes. And yet, if you look at Class B offenses, that's not necessarily what you see. You would think that between Class A, the life offenses, and Class see, the unarmed robbery, manslaughter, and drunk driving causing death, that you'd see these very serious assaultive crimes in Class B. But I'm going to give you an example of some crimes that were moved into Class B that I think it doesn't make a lot of sense. In 2006, embezzlement by an agent, if it was over $100,000, became a 20-year maximum penalty in a Class B offense. And then the same thing happened with false pretenses in 2011. And I also noticed in looking at the manual yesterday, the guidelines manual, that money laundering $10,000 or more is a Class B crime. And granted, that's connected with controlled substance offenses. But it's these property crimes that have a 20-year maximum penalty in a Class B in the guidelines that I wonder about, and they don't seem to make a lot of sense. And I think not only is it, not following the guiding principle that crimes of violence against a person are treated more severely, but I think, for example, if you look at it from a victim's perspective, would you rather be a victim of false pretenses over $100,000, which I think is a horrifying crime I would not want to be a victim of, or would you rather be a victim of manslaughter? Well, I would probably choose false pretenses. And yet, false pretenses seems like the less serious crime, but it's treated more harshly in the sentencing guidelines. And I'll give you one other example. In terms of Class B, you have these property crimes with, $100,000 threshold, but then you have what seems like a legitimate crime for Class B, which is resisting and obstructing an officer causing death. So I think that a sentencing commission really needs to work out the ranking of felony offenses and do some juggling, because I think the legislature likes to be responsive when there's a high-profile crime that maybe doesn't seem like it was punished most severely enough, or when there's a rash of crimes. But you can't do so in a vacuum. You really have to consider how this fits in with, the other crimes. So those are my comments today.
Good afternoon. I think I'm the only person on the panel that currently practices criminal defense. So I have a different perspective on the guidelines because, I started practicing in 2008, so I've always had sentencing guidelines to deal with. So the recommendations, and I don't want to repeat what have already been said, but the first thing I would do is adopt a recommendation to publish the sentencings from county to county. Having practiced in a total of 17 different counties, it was a daily basis for me to understand, if you had what we call straddle cell guidelines where a judge could give you probation, county jail, or send you to prison, you may not worry about it too much in Wayne County. But if you drove right up the road to Macomb County or Oakland County, you may be concerned that your client would be going to prison, and that would be a conversation that you would have. I agree. I believe that upward deviations from the guidelines should not be allowed, particularly after today. These guidelines are debated, studied. Every possible factor that can go into a case is listed. There's no reason for any judge to exceed the guidelines range in a case. And I think that opens the door for disparity. I've often argued when doing sentences, particularly CSCs, particularly if it's an alleged serial rapist or a shooting case where somebody shoots into a crowd, that 3 or more crimes against a person is factored, both for general crimes against a person, and CSCs. So the legislature contemplated that. They just may not have assessed the requisite amount of points to make a prosecutor or a trial judge happy, but the thought process was there, at least in my opinion. So that's one thing that I would recommend. Closing down the disparity in sentencing is another thing I would recommend, because as we've already seen today through the data, particularly with armed robbery, an armed robbery sentence could greatly vary depending on whether or not it's an individual who goes into a liquor store or gas station and robs a gas station, or if it's a drug deal or some sort of gang interaction that went bad. Judges tend to take those things into consideration in my experience when the argument is made. So limiting that discrepancy and disparities could bring some uniformity. A lot of the offense variables are so subjective, particularly asportation of captivity and aggravated physical abuse. And it puts, in my opinion, everybody on the spot. It is extremely difficult, especially if you're doing a CSE sentencing. If somebody's kidnapped or drugged from one location to another, I don't see too many defense attorneys arguing against asportation of captivity. It's the acquaintance rape or the date rape crimes where you put in a situation where you have to argue, well, Judge, everybody gets held down during a rape. I mean, that's the point. And you find yourself being in a position where you're trying not to belittle a victim, somebody who's either there's been a jury verdict that has found your client guilty or your client has admitted to victimizing this person. And now you put yourselves in a position when you're trying to argue guidelines where you may be belittling this person in front of a judge, in front of them, in front of their family. And so it really creates just a bad taste, I believe, in everybody's mouth to have to argue those things. I think moving armed robbery down to the B grid is fair, especially since the data shows that so many judges are deviating below the guidelines anyway. And I would agree that mitigating factors should be worked into the guidelines. You argue those every day at sentencing anyway. Most judges try and take them into account. Codifying those to give some uniformity would be good. And that's pretty much my recommendations.
Thank you. Thank you to each of our panelists. I'm so grateful that we started with that. It's interesting to see just in that brief amount of time, there's some coalescence around several of these recommendations, which I think is exciting. So before I move the conversation forward, did anyone have note cards? Do you have questions? Would you like to begin with those? I don't know where that stands. We offered note cards in case, I didn't realize there'd be microphones in case folks didn't want to stand up and talk. I want to make sure I'm responsive. So if there's questions from all of you that you'd like to pose or like to write down, we can start with that. Otherwise, I'll start with some a conversation and await your questions if you'd like to submit them. Does that sound good? Okay. So I was talking earlier, I just think I have many thoughts, but it struck me as I was listening to the presentations this morning, and I shared this with a few of you, that some of this for me is just, it's so straightforward. So, I was saying, if you found out that you had been diagnosed with cancer and your oncologist told you that you were going to be treated with the chemotherapy protocol that was developed in 1998 and hadn't been evaluated for efficacy since, that you probably wouldn't be enthused about that, right? If you had purchased a car and the last time the safety standards were examined was 1998, right? You wouldn't maybe feel great confidence. And so this for me is even just a matter of having the implementation of a policy that has not been reviewed in a systematic way with the express purpose of making recommendations to change, right? I mean, we have this wonderful report and we've had other analyses before, but practically speaking, a lot has changed since then. And so thinking about it, maybe trying to extract it from this sort of, potentially partisan conversation or this, sort of this giant task, right? When you think about it in terms of it's been a long time and things have really changed, and it's incumbent upon our system to make sure that we're operating with the most up-to-date information. I don't think that's a terribly radical observation to make. Okay, so I'll start, I guess, with the question for the panelists. Okay, so what's the barrier? Everyone in this room agrees or presumably doesn't voice significant objections to the creation of a sentencing commission or a policy commission, or is open to some of these. We've heard several of our panelists talk about downward departures or OVs that would include mitigating factors. So what are the challenges?
I think building the business case is the way I look at it. I mean, that's ultimately what it is. We were talking about these statistics are, they were pretty surprising, and they're important. And as Judge Yates indicated, a lot of our colleagues, a lot of people don't know, but we have to. But a lot of people are also going to say those statistics are 10 years old. When I look at the criminal division over at the Third Circuit Court, I actually went through, I want to say about a week ago, since the statistics were reviewed from 2012, I think there are about 17 new judges on our criminal docket because we have 23 judges in total. And so I think it might be easy for people to say, well, that doesn't reflect what I'm doing, that's someone else. And so I think it's really important to make sure that the data, before we go in with a lot of these structural changes, which I agree, I'm a full proponent of really looking at these, and I think there are some changes that need to happen quickly. But I do also think that you have to take the time to build the right business case, because you want to catch people and bring them in. You don't want them to be churned off from it by finding some of those loopholes that we know kind of exist just by looking at it briefly.
I'm going to answer this question with my president of MJA hat on now, because I haven't had a criminal docket for 10 years. I've run the specialized business docket, but I certainly have had lots of talks with my colleagues about it. In the last MJA executive board meeting last week devolved into a massive complaining session about taking away judicial discretion. So in the last 2 years, we've been through probation reform, parole reform, bail reform. And there are two ways in which I think judges are concerned. One is we feel the ground's constantly shifting beneath our feet. And the other is it seems like every single thing in the criminal arena coming out of Lansing is just another straitjacket, another straitjacket, another straitjacket. They don't trust judges. Why won't they let judges be judges? So I would encourage you to think about what seems to be a popular term today, low-hanging fruit. There are lots of things on which we judges all the way across the spectrum from left to right support. One of them is elimination of the 2-year consecutive term for felony firearm. We want more discretion. We hate that law. We've gone and testified repeatedly in Lansing to try to get it changed to just a guideline scored offense rather than a 2-year consecutive term. And I think there would be 100% buy-in from the Michigan Judges Association on that. Next, I know I've talked about it already, and Ian Yantis helpfully picked up on it as well. If you build in OV reductions, that's something we know how to do. We don't feel like our discretion is being cabined by that. Write a lot of those. Work with David LeGrand. Get those things in there. Third, if you want to do something that I think will meaningfully lead to people being released sooner, deal with the problem with truth in sentencing. I mean, we used to have disciplinary credits in good time. We don't have that anymore. Why don't we have that anymore? And that's something that doesn't even affect the way the judges do their jobs. That's the back half of it. I mean, that's when people are eligible for their earliest release. So personally, I support just about everything that we've heard about today, but speaking on behalf of the whole association, some of these things are going to be hard sells, but there are a lot of things that will meaningfully change how long people have to spend in custody, where you will not just be avoiding a fight with the Michigan Judges Association. You'll actually have us foursquare behind you. So those are just 3 ideas, and I'll float a couple more as we move through this, but there are lots of ways to accomplish what you want to accomplish.
I would support the commission, and I would support the commission immediately. Again, having practiced all over the state, I have never met a judge that said, I sentenced wrong. Every judge thinks that what they do is right, and judges are smart. I've honestly never met a judge that I thought was dumb. They can legally justify what it is that they want to do. And there are too many factors that are not in the sentencing guidelines that determine what sentence you get, whether or not your judge was a former prosecutor, former defense attorney, whether they were civil, whether or not a judge is black or white, the county the judge practices in. These are all things defense attorneys talk about before they go into sentencings. Whether your judge has a particular pet peeve with certain type of crimes, narcotic trafficking, gang crimes, violence against women. And I understand nobody likes control taken from them. I completely agree with that. But reducing the ability to use discretion also reduces the risk of there being improper disparities in sentencings. And that's why I think the commission is important. What do you mean?
Like challenges to the creation of the commission.
Yeah, politically, judges are elected officials, and you see it all the time with the Supreme Court, right? You have a Supreme Court, the U.S. Supreme Court. You take a Supreme Court justice who was just approved by everybody 2 weeks ago, right? And then when they move up to the Supreme Court, there's always a big fight, right? So judges have to be reelected, and they have communities that that support them, and they don't want to let those communities down. And there's I believe, a certain level of familiarity. Growing up and spending a lot of time in Detroit, certain things don't bother me. People who grew up in rural areas may not understand, gang crimes or, a robbery or the narcotics trade. And it's just something that is unfamiliar to them. It doesn't make them comfortable. So eliminating those disparities and discretion allows for us to legislate out a particular judge's lack of life experience in a particular area, which may make sentences uniform. And one thing that's not discussed is the probation department and how the Michigan Department of Corrections feel about your client. Because it's been my experience that typically general courtroom prosecutors don't have time to go through everybody's guidelines on a sentencing. Now, a specially assigned prosecutor will go through the guidelines. But typically, if it's just a general courtroom prosecutor, they look at what the probation department said, and if you argue against what the probation department said, then they just defend the probation department. So a lot of it, again, is something that we can't even address here, but just limiting the disparities in these sentencing cells is something that can make uniformity.
So I think we all agree that sentencing commission is a great idea. What it looks like or how we get there is going to be, I guess what we're talking about. I think it's really important that it be something that is created that continues to exist, and it's not just a temporary, let's pull together legislators and people from the field and judges and then have a temporary commission that makes recommendations. It needs to be an entity that's staffed and that it has an ability to go in and regularly review. I love this suggestion of having kind of the judicial scorecard, and not in a negative way. I think a lot of us really lose perspective on how our decisions come across the board. And like both Judge Yates and Mr. Johnson said, that those are things that I think would be really helpful for the judiciary and for other people, in the system. One concern I have about doing this at this point in time is that, having lived through the get tough on crime, when the crime really was going up in the 80s into the 90s, and when so many of the harsh punitive policies that we're now seeing play out were first going into effect. I guess that's a concern I would have, is if we do this right now, we have to be really careful to pay attention that we're not bringing that get tough on crime perspective, because I'm hearing a lot of it now, and it's sounding to me like the 80s was sounding. And I can remember that kind of vividly still. So that would be just a caution that we need to make sure that that's kind of somehow built into how we're creating the commission, so that we don't reinvent the wheel. I was talking to a representative on the lunch hour about the lack of institutional knowledge, as certainly with term limits in the legislature, but as we go through almost every organization, like, Barb retiring with Safe and Just Michigan, we lose the incremental institutional knowledge. So we need to find a way, in my opinion, that is part of what we build in, that we bring back, like the judge, the person on the screen, and had said about making sure we go down in the basement and dig out that old original, document, that we don't reinvent the wheel. We see what factors were being contemplated at that time and how that has played out over time.
I have a question for Judge Yates. So if we talk about low-hanging fruit for a moment, you referenced the Judges Association, things like scoring elements of the offense or triple scoring priors, PRVs, OVs, habitual. What do you think that or allowing not necessarily having to score the highest point level possible? What's your sense of how the trial judges would see that sort of stuff?
I can tell you right now that not having to score the highest point total would be extraordinarily well received. That's a classic exercise of discretion, and you're absolutely right. I mean, the fact that we've set up all these binary sentencing guideline scoring provisions is crazy. Everything comes in shades of gray, and sentencing guideline enhancements should as well. As far as the multiple scoring of criminal history, that's one of those things that for judges who've been sentencing under the guidelines for a long time, they just take as rote, but nobody's ever really thought about it in the sort of detail and in stark relief the way it's been presented today. And so if that were part of a larger package of sentencing reform, I think you'd be surprised how few judges would really be concerned about that. So Judge Shapiro makes a couple of really good points here, because if you get buy-in from the judges, and he's given us a couple of great ideas where I think you're going to get buy-in from the judges, we can deploy ourselves across the state and talk to legislators. We're always happy to go and testify in the House and the Senate to committees, and we'll help you build momentum for ideas like that. And I'm glad you brought those up, because those are two excellent suggestions.
Yeah. Oh, go ahead. Oh, Judge, were you finished with your comment? Did you want?
Yes.
Okay, go ahead.
And Judge Shapiro, if you have something, please jump in. So I wanted to follow up, and again, on what Judge Yates said, because I find his recommendations very interesting. But I'm not sure I agree with the idea that judges need to have more discretion. I think that mandatory minimum terms, pretty much everybody disagrees with those, and so I don't have a problem there. But I'm not sure that I would necessarily give judges more discretion at sentencing, in part because there was a book that came out in May. It was called Noise. I forget what the rest of the title was, but it was about noise and subjective, professional subjective judgments. And it was about unwanted variation in subjective judgments. And they had a chapter on sentencing. And they were talking about how, there's bias, but then there's noise. Noise is just this unwanted variation. And obviously judges have different they have different sentencing philosophies. But what was disturbing to me was that some of the things that influence sentences, even if a judge thinks, they're trying very hard to impose the best sentence for this situation. But, I think that we've heard that studies show that judges can be a little harsher with their sentences when they're hungry, right before lunch. And there was a study apparently that if your local sports team lost or your favorite sports team lost on Sunday, the judges could be harsher, sort of unconsciously, on Monday with their sentences. And what was the other one? That there was another one. Anyway, it was sort of disturbing by the things that influence in judges, and they're unaware of it. So I'm not sure that I want more discretion so that we can have potentially more variation. And I will say that this book on noise talks about decision hygiene practices and, sort of structuring the sentencing hearing so that the judge considers the factors, objectively that they think are most important and really takes the time to weigh them. And I think if you have mitigating factors, to find some way to objectively weigh them would be helpful. So that would be a good idea. The other thing I wanted to say is when Judge Yates talked about we don't have any, good time credits or disciplinary credits. And last year I looked at this. I sort of looked at the history of good time. And my conclusion, having gone back to the 1800s when we first had our first good time statute, was that the good time statutes were played around with and they were changed, by the legislature, every few years. But the longest period that there would be no change was roughly like 22, maybe 25 years. And then we're pretty much there now. So I'm very curious to see, because truth in sentencing went into effect in the end of 1998 for assaultive crimes and the end of 2000 for all other crimes. So we're pretty much there now. And I think, we have potentially a different generation of lawmakers. So it'll be interesting to see whether there's any movement there in terms of reductions for good behavior. So those are my comments.
Do folks have questions that you'd like to pose? Surely, the brain power up here. It's a lot. Okay. Yes, Josh.
This one's for Judge Yates. I'm a little bit curious as to how you navigate, or how you would suggest navigating, not just in terms of what are low-hanging fruit kind of things to deal with policy, but in terms of what this report covers, the difference between the disparity in length that's left to just having judicial discretion and letting judges be judges. How do you how can you navigate those two things?
Sorry. Let me start by saying this. I'm certainly not an advocate of unchanneled discretion. Because if you have unchanneled discretion, you're going to get what we had before we had any kind of sentencing guidelines at all, which is just wild disparities from judge to judge. The other thing I'd say is that no matter how much you try to limit the discretion of judges in sentencing, there's only so much you can do, because now that Lockeridge has come down and the sentencing guidelines are advisory rather than binding, judges can get to where they want to get to. What I'm suggesting is put in a series of discretionary provisions that incentivize judges to exercise their discretion in a familiar way and in a direction that you want to go. That's why, for example, I mean, first and foremost, I hate to keep pounding away at this, but OVs that are reductions, or as Judge Shapiro points out, you don't have to score 50 points if the OV requires 50 points. You can score 10 if you think 10 is appropriate. That's the sort of thing that leaves judges incentivized, as they would be, by the ability to exercise that discretion in the direction you want them to go. I had a conversation with somebody at the beginning of the session this morning about how trial judges are, in the main, very bright and really good at figuring out how to get where they really want to go in a case. And at the end of the day, the trial judge is going to be the one who chooses the sentence to impose. So what you want to do is create an incentive structure that gets the judge to the result you're trying to get to. I mean, for whatever reason, there's this impulse right now to tell judges exactly what they have to do down to the last detail when we're enacting these criminal justice reforms. And these are very well-intentioned. They're all going in the right direction. I'm very supportive of these initiatives, but you've got to get buy-in from the trial bench, because if you don't get buy-in from the trial bench, all they're going to do is fight against it. They're going to fight against it in the legislature, and then if it comes out of the legislature, they're going to fight against it case by case on the sentencing bench. And so I'm pleading with everybody to understand what's likely to get people on board with what you're trying to accomplish here and what's likely to be counterproductive. That's all.
I'd like to follow up on where Judge Yates is going with that, because it brings us to Lockeridge and whether we should restructure the guidelines in a way that allows for mandatory enforcement. And so that raises a couple of questions. One is how judges felt about the guidelines when they had to have substantial and compelling reasons. And of course, that's reasons to go above or below pretty wide ranges when you're talking about the A grid. And I think, I don't know if judges feel more hemmed in on the lower grids, but on the life max grids, they got a lot of discretion. But in terms of being able to make our guidelines mandatory again, it could be done, but it would take a restructuring that took all that judicial fact-finding out and made it more like what Kelly described this morning and restructured it so it was offense severity just went according to the offense itself in the statute. It would still allow for consideration of aggravating and mitigating factors, but only as a grounds for departure. How do people feel about that restructuring, anybody on the panel, and how do you, Judge H., think that trial judges would feel about a return to mandatory guidelines?
I've been dominating the conversation, so I'm going to defer on this one. I'll come back to it at the end of everybody else's response, but I do not want to go first, if you don't mind.
I guess I'll begin. I do think that there is a benefit to really looking at restructuring the guidelines. I think just remembering, once again, I mean, these guidelines were created in the 1990s at the time where policies were put into place that we know have had disparate impacts on minority communities. And to think that those guidelines are still in place, when I look at the mandatory, I've only been a judge under the discretionary guidelines, not the mandatory guidelines. So in truth, I can't really speak to how it would be like going back to the mandatory guidelines. But I'm also open-minded, and I guess this is what I was saying earlier. I think when you bring the data and you take it and you provide it to judges and you have those conversations, I think ultimately every judge wants to do what is right. They want to be imposing sentences that are fair and equitable, and they don't want to be the outliers either over or well below. And I think once you do that and provide that information, whether it's a mandatory, whether it's a discretionary sentence, I think ultimately, I do think we need to tighten them up a little bit. I think they're too wide, whether they're discretionary or mandatory or not, because we know that we can go, even when they're mandatory, you can find substantial compelling to go above, find substantial compelling to go below. I do think tightening them up is what we need to do, but we need to really look at the information, share it among our colleagues, talk about it. And I agree. I think we should be sharing what are the sentences in separate parts. It was stunning to me to see the differences in counties, because I don't know how my neighbor next door to me even sentences. And I think that would be an important part of having those conversations as we go forward. I don't know if I quite answered your question.
From where I sit, I think Lockridge was an unhelpful decision. The substantial and compelling standard was real in the sense that if I thought a sentence was out of line, I could talk to a colleague about it and say, well, where's the substantial and compelling? And I don't have that tool any longer. My own view, although it's long since passed, is that Lockridge should have made the min mandatory. Not mandatory, because that's the true minimum, and the min-max is just something that's said as a matter of policy, and that should be mandatory. I don't know why we have a Sixth Amendment right to a longer sentence. But Lockridge is the law, so at least for now.
Barbara, let me just respond with two thoughts. The first is, if you're going to try to dispense with the discretion that Lockridge necessarily imposes upon the guideline structure, I think one of the things you'd have to do is go to what's a pure charge offense system, not a real offense system at all, because that's the only way you can get there. If you're using any kind of real offense system, it's never going to work, because obviously there are all sorts of factors that bear upon the calculation of the guideline range. The other point I'd make is that one of your proposals, which is also, I think, kicking around in a proposed court rule from the Michigan Supreme Court right now, and which was the practice when I was in the U.S. Attorney's Office for the Eastern District of Michigan was to provide a forecast of what the guideline range would be. And if the computed guideline range under the sentencing investigation report turns out to be higher, you have a right to withdraw your plea if you wish to withdraw your plea. Now, having said that, I want to be careful in my representative capacity for the Michigan Judges Association because I had a lot of judges complaining that there's just no way in the state system you can accurately figure out what the guideline range is likely to be at time of plea. You just can't. Too many cases, not enough access to the resources in probation. Everybody says it's impossible to do. Now, impossible is never a good word to use. And I can tell you that in the federal system under Federal Rule of Criminal Procedure 11C1C, you actually can agree to a sentence. And whether you want to call it Cobb's or Killebrew or whatever you want to call it in the state system, when you're setting the guideline range, that's just kind of a variation on the Federal Rule 11C1C or Cobb's if the judge is involved or Killebrew if the attorneys are involved. So you can get there. It's just going to have to be resourced better, I would say. Because having represented lots and lots of clients in the Western District where they wouldn't tell you what the guideline range was going to be, you would plead and you would do the best you could to forecast the range for your client, and you'd say, I think you're looking at 6 to 8 years, and then it comes back 30 to life, and I can't tell you how often we got to that. And we fight it back down, and we eventually get to the right range again. That sort of uncertainty just engenders frustration with the whole system. And so if there's a way to make it work, and I don't know that we can make it work today, but if there's a way to make it work so that people would know at time of plea what their guideline range was going to be, it seems to me that takes both the uncertainty and the unfairness out of the system.
And, I alluded to this in my earlier comments, but one thing I noticed when I came back to prosecution after being gone for over 20 years was that propensity to sentence bargain. And it was precisely because of the real or perceived, the uncertainty. And we all, of course, try to guess what our various judges are going to do. And like you indicated, from courtroom A, B, and C, they could be, really quite different. And I find that, of course, in my county as well. And I do have our public defenders here who was an assistant prosecutor in the past. I don't know if he wants to, I don't know what the current practice is and how it may have changed. But, that is trying to, I like to have judicial discretion. I like to have prosecutor discretion. So when we sentence bargain, it is taking that discretion away, which I'm not fond of, but it's doing it because with some judges, at least the perception is, it's a wild card and we really have no idea. And the range can be so huge that defendants not want to plead guilty if, you might get 12 years more than you thought you were. So that is something that definitely is a real consideration, is how we have ranges and looking at habitual, consecutive sentencing, prior history, and things of those nature that might impact those really huge ranges might make it easier for us all to hopefully properly exercise our discretion.
I think the new court rule says, or that it's being considered is if it turns out to be different, they can withdraw the plea. I mean, I don't know how often in reality they'll be able to do it, but I think that's the notion.
Yeah, I know I'm going to send a comment in when it says different, because I would think it would be higher, not lower. I mean, if you're going to let people withdraw, I hate the use of the word different, because, I mean, you get a guideline range that's half what you thought it was, but at that point you think, hey, roll the dice, let's see what happens. But yes, that point is very well taken.
Oh, let me grab Ann and then I'll...
So I just want to follow up on that. There is a proposed court rule amendment, and the comment period, and I'm looking at my notes here, is through March 1st of this year. And maybe this is a good time to urge the audience today to consider writing a comment. So the proposal is that with a Cobb's evaluation, that there be a statement of the estimated sentencing guidelines range when a court offers a Cobb's evaluation. And then if the range turns out to be different, that the defendant has an opportunity of plea withdrawal. But, it seems to me you could write in as well and suggest that be for more than Cobb's evaluations. And, maybe if the Supreme Court hears from enough people, they would consider, some type of amendment that has to do with, putting a proposed guidelines range on the record at the time of the plea and plea withdrawal if it turns out to be different than expected.
I want to know what are specific sentencing reforms or ways that the guidelines could potentially be restructured that might best help to combat racial disparities. And specifically, when we think of things like the PRV, we know that similar to the way risk assessments often have racism by proxy, right? We know Black people in particular are more likely to be over-policed. They're more likely to be stopped. They're more likely to be overcharged. And so just blanketly having something like the PRV doesn't account for a lot of those things and can lead to people being, sentenced more harshly under the guidelines. So are there specific ways that you think the guidelines could be restructured? And then I am an advocate from the Detroit Justice Center, and so I want to know, are there ways that we as community members or advocates should be pushing or showing up in these spaces to support the call for the creation of a commission? So those are thanks. Thank you.
But let me start with something that I think is probably the best place to start. Many of you probably know that in the last couple of years, the state of Michigan has really broadened the opportunity to set aside convictions. And I think if you want to start trying to fix the problem, one of the best ways to start trying to fix the problem is get a clear indication that PRVs can't be scored on the basis of convictions that have been set aside. No, what I'm saying is, right, make sure that they cannot. Right, and as a result of that, that's the first thing that comes to mind, because I know that they're now setting up these expungement clinics all over the state. And if somebody's in that sort of circumstance you described, where just growing up in a community would necessarily lead to a higher likelihood of having a criminal record, if you can get that criminal record set aside, and then if you get that criminal record set aside, it doesn't count in your PRV scoring. It seems to me that at least it gives the opportunity for everybody to take care of the problem. I mean, obviously people have to avail themselves of it, but I think that the outreach efforts on that have really been tremendous.
I think that, one, the 10-year gap that is currently required is too long, and I don't think that a PRV should be equal to offense variables. Always, and sometimes when I have a jury trial, I may tell the jury that I'm like a JV Christian. I'm not all the way varsity Christian. So I've done things, whether it's drunk driving or maybe bootleg movies. And, I don't think there's anybody that's ever bought a bootleg movie went 10 years without buying a bootleg movie. So, but that's a crime. And I know, unfortunately, I've probably driven home 0.08 or above. So just things like that when you just take into the reality of life, and just the 10-year gap is just too long. And I just had a case last week. It's a drug case. My client possessed 0.05 grams of methamphetamine. His offense variables were 0, but his PRVs, I think, were over 60. So his guidelines were 5 months to 23 months. And he wound up getting 270 days. And when arguing back and forth with the judge, I actually did the math. It was 0.00015, 15,000th of a gram per day is what he wound up getting. So the PRVs can significantly enhance, unfairly in my opinion, a punishment for a relatively low level offense. And depending on the judge, a judge may, see that as a reason to do a downward deviation, or a judge, may say, no, the guidelines are what they are. Your client hasn't learned. I'm gonna give him 270 days. But, if in my opinion, the PRVs are creating a guideline system where somebody who doesn't even have enough drugs to get high can get 5 months in jail, then that's a problem.
I actually have a question for Judge Yates. Because I guess, newer on the bench, I'm curious, and I'm hearing you're speaking on behalf of, MJA and all of the judges. Is there a difference in kind of the way it's viewed based on the amount of years people have spent on the bench in terms of how they're looking at the prior record variables, a person's, history, whatever factors are, the discretion, things of that nature?
That's a good question. I think that what happens when judges have spent a lot of time on the bench is they get an ingrained sense of how things are supposed to go. And as a result of that, all of us who've been around on the bench a while fall into patterns. And I think it's really helpful when we have new judges come on the bench and they take a look at it fresh. For all of us to think harder about that. There's this natural tendency when they staff the judicial education programs to have the most experienced judges always doing the teaching. But if the most experienced judges are always doing the teaching, we're just teaching those ingrained notions that we've thought the same way for a long, long time. I was telling Judge Gleicher and Judge Shapiro at lunch about when I took over the Federal Public Defender's Office. I had been a federal prosecutor for 7 years at that point, and I'd done a lot of work in the Sixth Circuit, and I really knew Sixth Circuit and Supreme Court law inside and out. And the first thing I did when I was given the authority over the office is I spent the next 5 months of my life trying to convince Paul Denenfeld to come over. And for those of you who know Judge Denenfeld, my colleague on the court now, maybe the most brilliant lawyer and creative lawyer I've ever known in my life. And so he came over having never done any federal criminal defense work before, and it was fascinating to just see his mind work, trying to see his way around problems. And I would often tell him, great idea, but the Sixth Circuit already knocked it down. Great idea, but the Supreme Court knocked it down 3 years ago. But there's real value in seeing things with a fresh set of eyes. And so I like your idea so much, I may go back to Dawn McCarty and say, when we're talking about staffing sentencing instructor panels for MJI sessions, why don't we get an interesting mix there? Why don't we get somebody who's only been sentencing for a year and a judge from the Court of Appeals, and then maybe two people who have been doing it a long, long time?
I'm sorry, I have one more comment. We do have now a commission that's working on continuing education. And so judges are going to, at some point, we're going to develop a system where there will be continuing education for judges. And so as we're going forward and looking at what you're doing here and these, whether we want to kind of push some of these ideas, that is a ability to maybe reach some of the judges who've been around for quite some time, who maybe are more ingrained in their philosophies, and kind of have more of those conversations, cross-generational conversations.
Yep.
Because I can't relate to some of what is being said. If somebody pled guilty in front of me and they thought their guidelines were 5 to 23 and turned out they were 24 to 48, I would allow them to withdraw. I read that recommendation, and I was, I guess, surprised that that there was dispute over it. So.
One thing I'd add, just from the perspective of the appeals court, is there are judges who are regular appearers in our court for huge sentences. And, the guidelines largely began in the 80s because there were 2 or 3 judges in the state who wanted to give 100 years to a lot of people. And I'd be interested, although of course now I'm just talking theoretically, I mean, how much of some of these are really coming out of a handful of courtrooms. But we definitely see regular travelers in terms of sentencing way over the guidelines. Pardon? There would be more meaningful purport. Could you say it again?
Yeah. I talked federally, but my experience was sentences were almost never sent back for being too long. And, I was in the post-Booker world, so, it wasn't a substantial and compelling type standard, but do you think there would be more reviews of extreme sentences and more sort of rigorous appellate review happening, more sentences reversed for being too long and out of step with the guidelines if we had a different system? Because We're not seeing much of that right now.
I don't know, because it's so rare for us to see the prosecutor appeal of a sentence. Is that answering your question? I'm not sure I completely got it. Oh, I don't know the answer. My belief is yes, and more than just the number is, I don't even know what proportionality means, frankly. I know what the guidelines are, and I can understand substantial and compelling, but proportional is so subjective. It's difficult to make an argument that something isn't proportional, particularly, if you have an articulate and very upset victim, reasonably so. It can have an enormous influence. At least that's my belief. I'm not a trial judge, you have a dramatic story from a crime victim. It's difficult. I mean, I know if somebody in my family was a crime victim, I'd want somebody to go to prison for a long, long time. But that's not our function, right? Our function is to follow the law and impose appropriate sentences. I guess I'm just wandering here. I'm not sure what I was saying anymore about it. I apologize. But I do think that there are certain judges who we have no mechanism to address the problem of the handful of judges who are going to give as much as they can give, no matter what.
I want to check in. Anne, are you doing okay over there? Yes? I wanted to make my back to you, which is terribly rude. Sorry.
Thank you for checking in. I'll just follow up. I forget because I was an appellate lawyer. I forget that most of the departures are downward. And so when I'm thinking about judges having more discretion, of course, I'm thinking I don't want them to have more discretion to depart upward. But the idea that discretion could be a good thing, often slips my mind. And so I guess I come back to the idea that either having mitigating circumstances within the guidelines, or I also like the idea that you don't have to score the highest number of points possible and that you could give something that you think is appropriate. That actually might be a good way of bringing in more discretion at sentencing that would make it a more consistent and proportional process. Those are my comments.
Thank you. Anyone else want to jump in before I open it up for more questions? Everyone okay down there? Questions from the audience? Yes, John.
I just wanted to see that a number of the recommendations are around the intersection of habitual charging and the guidelines. I just wanted to see whether the panel has any reactions to those. Because the habitual didn't apply under judicial, and we've also had decisions like People versus Gardner that have really expanded the scope of the statute. So one of those.
So I can comment just real quickly, and I don't claim to be an expert in it, but so, because I practiced before the huge rise in the number of habitual supplementations, we used habitual supplementation in the 80s into the early 90s, but we had one prosecutor. We had bright orange folders. It was really viewed as the extraordinary case that you would habitualize. It might be a situation where someone's current charge just really didn't reflect what we thought was how heinous the individual's acts really were, because maybe we're missing an element or something, but when I came back, that was one of the most shocking things to me, to see how, basically everything that can be habitualized is often habitualized. Certainly, like I said, that was one of the first things I have done to try to change it. It has had in Ingham, it's had a couple of effects. One is we have far fewer people are sentenced to longer terms of years because of not using habitual supplementation. But an unintended consequence that I did not see and that is troubling is that part of my goal was to reduce the racial disproportionality. And unfortunately, the racial disproportionality has been maintained, even though we've lowered the number of actual people of all categories going to prison or for long terms. We haven't fixed the problem overall. So, but I do not speak for all prosecutors who have this for number one goal this year is to keep truth in sentencing. As the goal for the Prosecuting Attorneys Association. But habitual in particular and felony firearm as a form of, consecutive sentencing are things that I just think need to go by the wayside, because they're when you look at all the wonderful work that Safe and Just Michigan has done, we just know that those disproportionately impact on some of the most already over-incarcerated members of our community. So as from my perspective, I would be in favor of significantly reducing habitual offending back to more where it was. You know, when you habitualized somebody, it was an option, but it wasn't for sneezing.
In my experience, habitual offenders have just been a negotiating tool by prosecutors. Typically, if it's, maybe Wayne County, where you would always see, if there was a habitual charge, it'd be dismissed, you taking a plea. Some counties, if it's a habitual 4, they'll knock it down to a habitual 2. And I don't think it's necessary because, again, with the way PRVs are scored, whether a prosecutor dismisses or keeps a habitual, that is still taken into account in elevating the guidelines. So it depends on what county you're in. If you're in one of the counties where maybe Livingston County or Berrien County, where the habitual offender really means something, Jackson County, where you're really going to get more time, then it's definitely something that you have to think about. But I don't think it's necessary. I don't think it really serves any purpose. And I've had a couple occasions where, even though the habitual offender notice had been dismissed, prosecutors have come to court and argued for a upward departure from the guidelines. So I don't think it's necessary. It's just a tool that's used to induce pleas.
Other questions?
Yeah, hi, thanks everybody. How much support or resistance do you think there would be for the third recommendation we have on there is just make sort of across the board, lower the starting points. So how much, which I think would be have a major impact on reducing sentence length. So how much support resistance might there be for just that? Like just straight up, this is not rocket science. Just if you want to reduce sentence lengths, like lower the starting point. The judges I've spoken with, they say, when I'm calculating the guidelines, I use it as a starting point. And so, okay, what if we just sort of across the board reduce the starting point on that? How much resistance support would there be for that? It gets kind of to Aaron's point about race as well. So if raising sentence lengths disproportionately affected people of color. So if you reduce those, that will also disproportionately affect people of color as well. Maybe in a positive way in the sense of lowering sentence length. So, but that's like that's a tough political battle. I don't think that's low-hanging fruit at all. But, if anybody has perspective on support, resistance we might face with that.
In terms of resistance, I think that the bigger problem there is a legislative problem rather than a judicial problem. At least as far as I can tell, speaking for all of my colleagues across the state, if there are numbers in the A grid, we'll follow the numbers in the A grid. We're certainly not going to pretend like the numbers should be twice what they are. There, though, I think you're asking the legislature to do something which they might view as dramatic. I frankly don't know. I spent a lot of time working on legislative initiatives. I ran the legislative committee for years. And it's 20 years ago, I would have said that would be a non-starter. Today, maybe not so much. Don't know. But that's one of those that really, it's more important, I think, to have a good lobbyist than a good strategist.
I think, I'm but the lowly moderator, but I just wanted to make a point I was thinking about as we were talking. What's interesting for me, so I approach this clearly from an academic standpoint, and I was thinking about two things. Number one is just the divorce of the numbers on the grid from sort of the reality of what they serve, right? So in the most philosophical or theoretical sense, a sentence is the cost we attach to your wrongdoing. And I don't think that if you think about it simply in those terms, in 30 years, we haven't really reassessed whether or not the costs that we have attached are reflective of the wrongs as they exist today. I don't know, framed in those terms, that that's particularly, radical or revolutionary. But the other thing too, one of the things that struck me as we were talking is how much of this, I heard somebody say at the first break, this is really in the weeds. This is like inside baseball stuff for people who love policy. But really we're talking at a very institutional level. And everyone has reflexive sort of defensiveness over their own integrity and their own standards and intellect. And that's true of judges and defense attorneys and prosecutors and legislators. But we're really just talking about institutional changes, and when you see that institutional mechanisms produce disparities, that doesn't require malice of the actors in those institutions. And so I think pitching it that way might help to negate some of the resistance that one might experience. But I'm not an expert, I'm just a moderator. Mr. Johnson, I didn't mean to interrupt you. Would you like to go ahead?
Yeah, I just don't think whatever you do to the guidelines, it is not going to adjust racial disparity if one exists in sentencing for particular grid. It's not going to happen. Wayne County was it was like a closed society. It was like a high school in terms of, and not in a bad way, just the familiarity you had with the judges. And when I was significantly practicing in Ingham County, it's the same way as we were talking at lunch. You knew what judges you suspected thought black people were dangerous. You just knew. One of the most exciting moments in Wayne County was when you got your blind draw, right? That determined how you litigate the case. And we have Judge Kenny in the back there. You knew if you were going at that time, Judge Kenny. I've only practiced for the Judge Bosley a few times. You knew if there were certain judges, you might be okay. There were other judges that you knew it was going to be a fight. And there's nothing you can do. There's nothing the guidelines can do. And you would see it. You would see the judges. They would always associate with people that look like them. You see them all walking in and out of the building with people that look like them. So you knew. And it's just, I feel kind of disadvantaged because no other defense attorneys here to back me up on this. I see Russ. Okay. Oh, yes. I see Marla. Who's Marla, right? Mara, yeah. So you knew. There's nothing that guidelines are going to do is going to change. It's going to take a judicial, I think Thurgood Marshall called, the paraphrase Thurgood Marshall said, revolution is good, but evolution is permanent. It is a judicial evolution that is going to be needed to change racial disparity. It is going to take, and I'm not saying that's a good thing. Whether somebody's more comfortable with a crime that somebody's committed, that's not necessarily a good thing. But if you have somebody that grew up in an environment where there was very little crime, very little diversity, their only association with diversity was what they saw on the news, they became, and the reality of it is, most judges start off as prosecutors. Very few judges have both a prosecutorial and defense background. So they became prosecutors for a reason, because they have a certain belief system. They don't divorce themselves of that belief system when they sit on the bench. And so it's just going to take time, and it's going to take a lot of fighting and limiting that discretion that they have to try and combat those things. But other than that, I just don't think adjusting the guidelines is going to get to where you're trying to get to in terms of racial disparity.
And I just want to comment because I focus a lot on the beginning part of the system. So I focus on what the police bring to me because I don't initiate. We don't have our own investigators. I don't initiate crimes or charges. So I wait to see what the police brings me. The data is pretty universal, our data locally, and then the data statewide and nationally when we get it, that the racial disproportionalities exist from the very beginning. So if I have two similarly situated individuals, but a person who is a person of color is stopped, searched, and charged, the case is brought to me, then that means that as it goes through the system, by the time it gets to the sentence, the sentencing phase, it may have snowballed. In other words, the disproportionalities at the initial arrest or stop contact have now escalated throughout the system. Who's going to get incarcerated in jail pre-trial? Though we know that there's racial disproportionality. I know that's not the subject today, but it's one of my favorite subjects, so I'm going to go there anyway. But it builds through the system, so by the time we get to the sentence, it's incredibly important, but it's already built on everything that gets you to that point.
And I just want to be clear. I'm not, the diversity of the judge doesn't seem to matter. I mean, there were stories that you were told from some of the older judges who, and some of these judges I've known, I've seen, I've talked to them. There were a lot of, I call them the civil rights era judges who saw crime, particularly, black on black crime or urban crime, as the greatest betrayal to the community. So I didn't bring in to the race of the judge, but I want to make it clear. I'm not saying that just because a judge is white or black, it means that the racial disparity is going to change. It is something that I believe, in my experience, depending on the age of the judge and the mentality of the judge, is consistent regardless of the ethnicity or nationality of the judge.
I'd also like to say, I think what this brings out is it's important to look at this from a holistic approach. And so I think, and one of the first things I had said, and I think everything agrees, you have to have the Criminal Justice Policy Commission, and I think that's your first policy priority. And then you can look at all these individual things, but then you're going to miss some of those bigger things. So at the Third Circuit Court, we have our Diversity and Inclusion Committee, and thankfully that's we have such great leadership that supports that. And we've come up with a plan, but in that conversation, I think, and what I've learned through years of being on that is we really, part of some of what's happening with these sentencings are looking at our own implicit biases, or how we are viewing people, seeing people. And I agree with Mr. Johnson. I've spoken with judges who've taken, black judges who've taken the tests about implicit bias and found that they had a bias against people from their own community. And I think that it's because of things that we're not conscious of, or we don't understand. And I think part of all of this is having these longer, greater conversations, and how can we, when we are sentencing people, not be sentencing them with our biases in mind. And what studies have shown is if you're aware of your biases, you're less likely to sentence according to those biases. And that's part of this whole conversation. And so I'm afraid of kind of going piecemeal with some of these reforms that are recommended, because then other things are going to slip in by the wayside. I think that talking to people with the piecemeal stuff so they're comfortable with it, like it's going to give judges more judicial discretion and, maybe not having to assign these. I think that's great as talking points, but if you go in with just that, then you might be losing kind of the big picture of what you're trying to achieve.
So we have about 10 minutes left of our session. So I thought we would start at the end and when I teach, I call these Jerry Springer final thoughts, but that doesn't seem fitting of our occasion. So we'll just call them our wrap-up final thoughts. It could be anything, maybe something that another panelist has offered that you'd like to touch on, or a charge to leave the audience with, but everyone will have a chance to share sort of their concluding thoughts.
How can you ever ask a lawyer to, not talk, right? So just first of all, groups and meetings like this are really important. This report is fabulous. The work that is done, every time there's something that we can really point to where someone has thoughtfully looked at a great deal of data, even though a lot of people won't look at it, those of us who will, it can really change how we approach it. And so I guess I liked Mr. Johnson's comment about the evolution. I think of that, the Beatles also said something like that. And that, sometimes the changes are being worked on for many, many years, and then they seem to happen overnight. it's very easy sometimes to give up. I plunge into despair with regularity. In fact, when Barb originally asked me to be on this panel, I said no because I was in a place of deep despair. And I thought, well, I can't add anything because, everything's just so shitty right now. But it's not. Every day there's something good. And that's, I guess, my charge is that, to focus on that next thing where we can make a difference for an individual or a piece of legislation or something that happens, and we can. And so that's my not in despair comment today.
I think regardless of whether or not there's legislative change, this is important. I mean, our sentencing in Jackson counties are Wednesday and Thursday. And I'm going to start incorporating things in this book this week. I don't need, it'd be nice if the, judges as a whole made decisions, but every judge I know, every judge I've ever practiced in front of is an intellectual. They like to think, and they like to think on intellectually and like to make logic-based decisions or what they believe to be logic-based decisions. And if I can incorporate statistical things that are in this book into real-world practice and lower, a sentence a year or two, then that's a win, regardless of what the legislature does with it. So just having these conversations and producing this data is important and will make a difference.
I agree with all the comments that have been made. I do think that everyone wants to do the right thing, and it's just about giving people that information, having these conversations. And I do think we can get to the point of doing the right thing. We might not all agree on exactly what the right thing is, but I think that we're in a special time right now where it is the time to we can get some traction on some of the things that we want to go forward with and make changes to. So.
Most of the criminal justice reform that's been accomplished in the last couple of years, and there's been an extraordinary amount, has really been a function of collaboration and good strategy. And if you're going to do this, I would encourage you to follow that path of collaboration and good strategy. I was interested to hear, for example, that the Prosecuting Attorneys Association of Michigan has as their main priority no erosion of truth in sentencing. Well, if that's going to be a barrier, you need to know that going in. If you're working with the legislature, you've got to understand that the members of the legislature have to have extraordinary bandwidth, and this is just one thing across a really broad spectrum of considerations they have. The education process may be substantial, but I would tell you that I've found that we've had really good experiences dealing with Chairman Graham Filler and David LeGrand in the House Judiciary Committee. They get the stuff. They know how it works. They really will understand what you're trying to do. And if you want to do something by rule amendments, that's a whole different process, because then you've got a fairly sophisticated audience at the State Court Administrative Office and, of course, on the Supreme Court. And then, as I say, buy-in from groups is going to be key. And I'm always happy to talk with anybody. We have a terrific legislative team, too, at Michigan Judges Association. And I know that CDM can be helpful as well. So all I'd ask is that before this effort's launched, that you think about that which is possible versus that which is going to be trying to scale a mountain, and think about how you want to approach it. Because I think that it's, despite the fact that there's been so much change in the last couple of years, I think you still have a relatively receptive audience if you can make the kind of persuasive presentation that's been made today.
Deviations.
So I would say that obviously a sentencing commission can do a lot of good, and there's in so many different areas, although I think it will take time. In the meantime, I think perhaps, given that it's the judges who are exercising discretion, then maybe we do look at that, and we look at giving them information about what their colleagues are doing, which I think is a great idea. And then also thinking about what's called decision hygiene, again, from this book about noise. And it's talking about how the judge reaches the decision, and maybe just educating judges there that there are some judges who, just quickly reach a very intuitive judgment about what the sentence should be, and they don't necessarily listen to all of the presentations. But the better approach, they say, in terms of eliminating unwanted variations, is to delay that intuitive judgment as long as possible and to try to actively seek as much objective, information as you can from all sources. And so maybe if we're talking to judges about how they form their decisions and then also, what their colleagues are doing, maybe that's something we can start with.
Would you like to say anything?
I didn't really have anything to add, except I think the one thing we didn't talk much about that I think would be helpful, is because I'm continuing to think about Lockridge, is the base sentence for the offense, and then everything, all the fact-finding occurs only in the context of a departure, because the fact-finding in the guideline scoring is very difficult to. I'm looking at the appellate level. It's very difficult to say a judge made an error in scoring a particular guideline when there's evidence that goes both ways. Whereas I think in review of a departure sentence, we have more authority to examine the grounds for that departure than we do for the grounds for scoring. For example, an OB7, which is really a devastating score, and it's not that hard to get scored for OB7 in some courts. But there's not that much we can do about it.
Okay. Well, thank you to all of our panelists and to Safe and Just Michigan and to all of you. You've been very attentive. Thanks.